We're live. Okay. Well, hello and welcome to the. I don't think I'm live yet. Oops. Hello and welcome to the Flipping and Wholesaling Houses in New York show. I am Michael Pinter, where I teach you how to start flipping or wholesaling houses in New York, or if you're already doing it, how to grow your business. Got a question of what are purchase agreements, which what we call in New York contracts, contingent on? The easy, simple answer is whatever you want them to be. But if you stay to the end, I'm going to talk to you about what my contracts are typically contingent on when I buy and when I sell. So in most states, in fact 49 states, a typical purchase contract, a purchase agreement, or a P&S, they call it purchase and sale in some places, would be contingent on the buyer. The buyer would have a contingency of an inspection period, right? So let's say 2 weeks, 30 days, that's your inspection contingency. That is typical in 49 states, right? Where a transaction takes place between a buyer and a seller. I want to buy, you want to sell. I can whip out a contract, and we're in contract. And typically, I have time to get out of it. Typical in California, also they call it an escrow period, where the buyer has a way out. That's not the case in New York. In New York, all inspections and most of these contingencies take place before the contract happens. So when I agree if I'm selling a property, buyer agrees, that buyer should schedule an inspection beforehand, and any repairs that he requires are going to be an addendum to the contract. So when we sign the contract, inspection's done, and there's no more inspection contingencies. Now, in New York, again, the real estate transaction does not really take place between a buyer and a seller. When a seller agrees to sell me a property, the seller's attorney generates this contract and sends it to my attorney, and that's where the negotiation takes place between these two attorneys, who are each earning thousands of dollars and are going to probably spend a lot of time on stupid bullshit. Very common for them to argue over $500, $400, ridiculous things that they do just to prove that they're worth their legal fee. Very typical. Again, closing costs in New York average around $10,000 on my purchases. That's a $300,000 to $500,000 purchase price. Closing costs in most other states are significantly less, much less. Most of the closing costs in New York consist of title charges, legal fees, taxes, and all those things are very high in New York. So, if you are buying in New York, you have to understand that, if you've been watching gurus on the internet and who are telling you that wholesaling is risk-free because you just have an inspection contingency and you can just get out of the contract, it's not the way it works in New York, right? So if you have a deal you're afraid of getting into, you can contact me. I'm happy to help you. Now, when it comes to purchase agreements, you can make it contingent on anything. So if you're a seller and you want to make this contingent on a time, you can put in a certain time and you can make the contract time of the essence, which means that if you, let's say this must close in 60 days, you make the contract time of the essence 60 days. After that, if you give it, if that's in the contract, you can theoretically make a motion to keep the deposit, which, by the way, in New York is significantly higher than the other 49 states, typically 10% in New York. I try not to give 10%, but I still give significant deposits, $10,000, $20,000 typically. So you can make a contingent on it. You can make a contingent on anything, right? The contract is an agreement between two parties, and it can be contingent on either. From a buyer, you could, in theory, put in an inspection period, right? It's just that the seller's attorney is probably going to look at that and go, screw this, right? The reason why there's no inspection periods in New York, and the reason why EMDs, earnest money deposits, are so high are because attorneys do not want to create a contract that they feel the buyer can just walk away from, right? Remember, it gets generated by the seller's attorney, not the buyer's attorney. And a seller's going to look at a contract where a buyer can just walk because he changed his mind. And he says, what am I wasting my time for? Do your due diligence beforehand, right? That is really why it happens. Now, one of the reasons why people sell to investors like me is they want certainty. And some people understand and some people don't. But a typical retail contract, so a seller just selling a house to another buyer, they listed it for sale, buyer comes in, has one major contingency in it for the buyer. That is the mortgage contingency, right? A financing contingency, where basically he writes, if I can get a loan under these terms, then I am happy to close. And if I don't, I can get out. That really is a get out of contract free card. And it happens to people all the time. It happens to me, right? Somebody's in contract for 2 or 3 months, and they go, oh, sorry, I got denied. Now, I have a lot of experience in the mortgage business, and I can tell you that it's very, very easy to send someone a denial letter for a mortgage. Very easy. Document expires, send them a denial. They say, hey, you're denied. And that really is a get out of contract free card, because I've had situations in my previous career where people said to me, hey, I just want to get out of the contract. Can you give me a denial? I just changed my mind, and I gave it to them. So what an investor provides is a non-contingent contract, right? My contract has no contingency in it. The only way out of the contract is if the seller cannot deliver clean title. So that happened to me in a situation recently where there was an easement on the property that I didn't know about, and I couldn't do what I wanted to do to the property. And the guy fought me, and it was a big deposit, six-figure deposit. But eventually I won in court and got it back. So it cost me, I don't know, $18,000 in legal fees to get my $100,000 deposit back, but I got it back. But that's the only reason why I can get out of a contract, is if the seller can't deliver clean title. Now, from a seller's perspective, you really don't have a way out of the contract. Okay, so I have a situation going on right now where they said they changed their mind, and I'm like, you really can't change your mind at this point. So I intend fully to, if the sellers don't go through with it, I mean, we're supposed to close later this week, and they may go through with it, but if they don't go through with it, I am prepared fully to file a list pendants on the property, which is the same as if I was a mortgage holder and they were foreclosing, and I was foreclosing. And I'm prepared to start a lawsuit against them to sue them for specific performance for the entire purchase price. That is where I stand. I know there's some family politics going on, but it's not my problem. We've been in contract a long time. These are not new family issues, something that they should have known about before they went to contract. And I'm buying this property one way or the other. And they're going to call their attorney, and their attorney is going to tell them that they have no choice. That's really what's going to happen. So it's important to understand a contract can be contingent on anything, right? As a buyer, you can make a contingent on the fact that certain things are as the seller says, right? Whatever the seller represents to you, and you put it in writing in the contract, it can be contingent on that, right? So I just saw a lawsuit going on where seller told a buyer on a multifamily in Miami that he had a permit for a short-term rental for Airbnb. Then the buyer found out he didn't, and now he's suing them to reduce the purchase price significantly, right? So these things happen. Whatever seller represents, if it's put in writing in the contract, it's got to be true, or the buyer can get out of the contract and say you can't deliver the property under the terms that we agreed on. So again, these are things that are negotiated. They can be, any of these things can be negotiated. Time frame, issues specific to the property, all these things can be negotiated as long as they're put in writing in the contract. Your side has a way to get out of the contract if it's not delivered. I know in general, a standard contract that's got no other contingencies in it is going to be contingent on the seller delivering clean title. So that means that so in New York anyway. I know in many other states, a seller can deliver a property without clean title, right? Subject to certain liens, subject to the existing mortgage, right? That means I'm giving it to you and you're taking on the mortgage, right? It's your problem now, although theoretically it's still in the seller's name. But these things happen all the time in other states. In New York, it's really not typical for that to happen. Title companies in New York are much more inclined to give everything clear. So I remember I used to buy a lot of properties at auction. I never had to run title before because I always knew I was getting the property free and clear at auction. But I knew people that were buying at auction in Florida. They had to run the title before every time, because if that guy had some tax lien, they were getting the property without that tax lien being paid off. That was going to be their responsibility. So that wasn't an issue in New York. Never an issue in New York. It's one of the big advantages of New York. You always get something free and clear unless it's specifically stated that it's not. So I actually just bought a property where it was complicated and I had to take it subject to liens that are going to be paid off after, but it's very rare for that to happen. Very, very rare in New York. And it's one of the great advantages of New York, that you're going to get a property free and clear. You don't really have to run title until after you go to contract, because it's a seller's responsibility to cover any liens or loans or anything on the property, and there is no subject to in New York. So I hope this was helpful. If you're interested in all the ways I can help you, go to howtoflipnewyork.com. If you are interested in finding out more about a course I have that teaches how to do what I do, go to howtoflipnewyorkcourse.com. If you are interested in finding out more about one-on-one coaching, go to coaching.howtoflipnewyork.com. If you're watching on YouTube, please subscribe. If you're watching on any channel, please click the thumbs up. Those likes really help me. And please keep the comments coming. I try to go live 5 times a week, and I don't always know what to say. You can ask any comment. Doesn't even have to be about the video you're watching. If it's a simple answer, I'll just reply. If it's something I've covered before, I'll send you links to the videos. If it's something new, I'll do a new video on it. But I really, really appreciate everybody watching, and I appreciate all the comments. So please keep the comments coming so I have good topics to go with forward in the coming forever.